Hi, everybody. Welcome to Square Off. Eric Gage is joining us today. And Eric, world pole dance competitors have launched several, stop laughing, they've launched several petitions calling for Olympic authorities to add their sport to the next games. And I love this idea. You know, it's not just something strippers do. It takes real talent. And I think it'll make for pretty good TV.
You know what, Liz? I think we need to draw the line at some point. Sure, their athletic abilities, it's undeniable, but it's still an event that is overwhelmingly associated with strippers and strip clubs. You walk into any room in the world and see a pole, you don't associate it with an Olympic event, you associate it with Kid Rock. I just can't take it seriously, but we'll debate that later on Square Off.
The Supreme Court of Canada says that mandatory minimum sentences for gun possession is unconstitutional.
Yeah, the ruling came down yesterday morning, and it wasn't the news that the federal Conservatives were hoping for. Their tough-on-crime agenda called for a minimum prison sentence of 3 years for a first-time offender and 5 years for a repeat offender.
As expected, some are praising the decision while others say it was the wrong call. Representing both sides of the debate, we have Rob McDonald. He's a retired Toronto police officer, and Jeff Manishen. He's a criminal defense lawyer. And Jeff, you agree with the Supreme Court of Canada, but wouldn't you say that mandatory minimum sentences would deter people from committing crimes?
No, and in fact, the Supreme Court of Canada relied on a fairly substantial body of evidence to say they do not deter such crimes. It's been the experience in the United States. They don't. The Canadian government...
How do they get that evidence? Like, do they ask criminals, you know, how would you feel if? I mean, how do you actually collect that kind of evidence?
The way to do it is look at statistics before and after the legislative regime was implemented. If you didn't see any significant decrease in crime, it's fair to say they didn't have any desired effect.
So, Rob, you're on the other side of the fence here. You think this is a pretty big mistake. Why do you think so? You know,
I think, unfortunately, we have to look at the bigger picture of the society and the benefits to having these people put away. And it starts, actually, with their first sentence. If they get a slap on the wrist, there's no deterrent there. So at some point, you have to jump in and say, this is unacceptable in our society. My last case last year involved a gentleman. He was, you know, when we arrested him, he had enough drugs to make the fellows at Breaking Bad impressed. And he also had a gun, and this was his third gun charge. And he was only concerned about the gun charge because he knew he was facing substantial time.
Okay, so Jeff, can you tell us what is the average sentence for someone who's found in possession of a loaded weapon?
Well, I think the way that we could phrase it, Liz, is it will depend on the individual circumstances. If you had someone with any kind of record, the sentence is going to be a lot longer than for someone who didn't.
What's long?
Well, I would say a penitentiary sentence for a first offense is a long sentence, especially if all we're dealing with is simply the possession of the loaded gun without the proper license and authorization to have it. And the difficulty is this, to respond to Rob's point, the key feature of the legislation here is it was a minimum, and it didn't permit circumstances under which we'd say, gee, that would be too harsh. Ultimately, one of the two accused, a fellow named Nur, got 3 years for a first offense where he was in possession of a loaded handgun. And even though the Supreme Court of Canada said the sentence, the statutory provision was unconstitutional, they upheld the 3 years for a first offense possession of a loaded handgun. So when we look at that, that's a significant punishment for someone with no record, 19 years old, for the act of having a loaded handgun in his possession.
But let's be fair here. Any reasonable person knows it's illegal to possess a handgun, and a loaded handgun at that. Nothing good is going to come from that.
Sure. The difficulty that you have, Eric, is that the legislation is framed more broadly than that. If you're in possession of a loaded handgun under circumstances where you don't have the license to possess it there, or even the handgun that isn't loaded, there's ammunition readily available. There are circumstances that I think we could conceive of where someone should not get a sentence anywhere close to that long. It could become more of a licensing type of offense. So, and Rob, the problem with the legislation is it doesn't allow for that.
So, Rob, is your issue then you don't trust the courts or the legislative to make the proper decision should they be viewed on a case-by-case basis?
You know, unfortunately, the Criminal Code of Canada can't be written for each and every 35 million of us. There has to be some standards. And I think this is a standard that needs to be met and needs to be kept. Unfortunately, as much as I appreciate the skills and knowledge of the Supreme Court of Canada, I don't know when the last time they walked in very difficult neighborhoods was and actually dealt with the people on the street that live in those communities, that live in fear. And it's not right. And you know what? If we have to send a message Let's send it. And hopefully, when we do put these people away, we give them the opportunity to be rehabilitated so they don't make that mistake again.
Jeff, in your experience, is it possible for a suspect that's been charged with carrying a loaded weapon has actually been not done any time in jail as a result of that?
Well, if you had a situation which the finding of the gun was ruled inadmissible because of a charter infringement, or if there were circumstances that could constitute an offense, sure. Are there circumstances where somebody in possession of a loaded gun would not get any kind of jail time at all? Did we see that before the days of the statutory minimums? It was really rare. Jail sentences were highly likely. The key was you didn't need to make the changes, as far as I'm concerned. You didn't need to tie judges' hands. And that's what 5 judges of the Ontario Court of Appeal found, and 6 of the 9 judges of the Supreme Court of Canada found. And so it's not a matter, Rob, of walking the streets. I've never walked the streets, but I can tell you if a sentence imposed by a judge is too harsh and excessive, if it's grossly disproportionate, I don't have to be out there to see that. And that's not to say that people who commit serious crimes don't get punished. It's just a matter of allowing for judicial discretion. I would think you'd agree with the value in that, wouldn't you?
I agree there's some value in judicial discretion, but there also has to be a minimum bar set. You know, the Eaton Center shooting with Christopher Husbands, that's a prime example. There are thousands of people there that are negatively affected for the rest of their life because of the actions of one. You know, the Mayerthorpe shooting, so it's not just a city or an urban problem. You know, that was a rule setting that cost 4 RCMP officers' life. And that gentleman had a history of gun issues, and he was out.
And neither of those people would have been deterred by whatever you do by way of statutory minimums. The criminal code can't be written.
I think is your point, right, Rob? They might have been in jail as opposed to out on parole?
Absolutely, because, you know, unfortunately, in some respects, the escalation of you get caught once, you get one sentence. You get caught a second time, they bump it a bit. It's in our system, it can be quite a while before you find serious time being served by people.
You're wrong, Rob, and they don't bump it a bit. The statutory minimums could, even without them, somebody for a second offense for a firearm matter could get 5 years, 7 years. That's what happened in the cases before the Supreme Court of Canada. They upheld those as valid. But you still have to look at it that sentencing, a statutory provision, isn't to be a one-size-fits-all. There's no benefit in restricting judges' discretion. I have to tell you the cases I've seen where judges feel really torn when they can't give somebody a sentence that they feel would be appropriate in the specific individual circumstances because of minimums like these. They don't work.
Yeah, but we also have judges who don't want to step on the toes of precedent that's already been set by another judge and go harsher, because the first thing that's going to happen is defense counsel is going to say, in a similar matter, your fellow learned judge only gave that person X, my client's getting Y, and that's disproportionate, when it's not right.
Well, you do have a concept of rule of law, but you also have the power of appellate courts to be able to reverse and increase sentences, and that's happened too.
So, Jeff, how do we deter them? This is all about deterring. We can agree with that. So how, if there's no minimum sentence, and as Rob mentioned, there's a lot of these offenders aren't really afraid of the sentence that they're going to get in terms of other stuff, just a gun, one prior to with the structure we had before. How do we deter them from happening more often?
The major deterrent measures that I've read over the course of years are the likelihood of apprehension, likelihood of detection, and certainty and speed of that, and likelihood of conviction after a trial. You need to be able to provide the resources that allow the police to be able to investigate and court resources to be able to deal with cases more efficiently than we do, given the limited resources we're provided.
And Rob, in your experience, do you find that even after jail time, people come out of jail and they go right back to doing what they were doing before with the same crowd, perhaps carrying a loaded weapon?
Yeah, sadly, that's the case. I think, you know, I can agree with defense counsel. When we incarcerate people in this country, we don't do a very good job of providing them opportunities to better themselves. And, you know, that's a big piece here. But yeah, you know what, even prior, when somebody is arrested, charged, and getting bail, and given conditions when they're on bail, quite often they're breaching it. They're not going to abide by those rules because they don't think it matters to them. Yep. And, you know, we need to deal with it.
Yeah, I still think it's something that you'll find people are on two sides of the issue with. That's Rob McDowell, Jeff Manishen. Thanks so much for your time today. Appreciate it.
You're very welcome. Have a great day.
Thank you. When we come back, why are kids in the applied program in high schools graduating at a lower rate?
Yeah, is it a coincidence or perhaps a flaw of the system? Is it time to trash the whole idea of applied versus academics in the approach to education in Ontario? We'll find out next.